So I would like to welcome everyone who is listening in on the presentation today. I am retired Justice Evelyn Stratton. I served 16 years on the Supreme Court of Ohio. And while I was on the Supreme Court, we did some of these grand rounds in person in those days at OSU. And then we also did them at several other universities. And I focus really on criminal justice and mental health issues. And I left the bench about 12 years early to really spend time in this area. And so we started up the grand rounds after the pandemic, or actually during the pandemic. We started up the grand rounds, but we did them virtually because this way we can tape them and send them to all of our psychiatry hospitals and our training hospitals and our psychiatry schools, so they get a lot of extra use. And I also send them to all the law school deans to use in their criminal justice courses. So I've been involved with the Attorney General when it was Mike DeWine for 8 years, and now with Attorney General Yost for the going on 5th year. And we have different committees for the Attorney General Task Force on Criminal Justice and Mental Illness. And one of those committees is on psychiatry and treatment. And we started the grand rounds through that committee. And our co-chair is also our speaker today. She's the co-chair of our psychiatry and treatment. She represents the psychiatry side. And then we have a mental health professional that heads a mental health board for their county that heads the treatment side. So we're very excited to have Dr. Joy Stankowski. She received her medical degree from Penn State, and then she interned at the University of Virginia in internal medicine and psychiatry, had a fellowship in psychiatry at Case Western Reserve, and then started working for the state of Ohio at the North Coast Behavioral Healthcare, where she is now the lead clinical officer. She also is very involved in national and forensic education, both state and nationally. She has a lot of faculty appointments. She's been past president of the Midwest American Academy of Psychiatry and Law, and also maintains a private forensic practice. So she's got boots on the ground experience. But I've gotten to know her well as co-chair of the psychiatry committee, and she's just a doer. She is someone who takes on something, runs with it, organizes it, plans it. She's just been a great partner in this. And she's just passionate about the forensic psychology issues. And we thought we really need to educate our students to understand the huge need in the field of psychiatry for students who are willing to go into the forensic area, into the criminal justice area. We have a huge lack of psychiatrists that are willing to serve in that area. And yet it is by far the largest population of persons with serious mental illness. And so hopefully she will go into some of that data when she speaks to us. So I'm very excited to turn it over to Dr. Joy Stankowski. I think you will find her presentation very practical, very useful, and she will be available to reach out to by email afterwards if you want to follow up and maybe see how you can get involved as a student in any of this work. We have lots of opportunities for you. And you could also join the Attorney General Task Force Psychiatry and Treatment Committee if you like. They meet by Zoom 4 times a year, and it's a great way to network as a student and to learn a lot about the subject matter. So if you're interested in that, Joanna has the information. She can get it to you and tell you how to join. And with that, I'm now going to turn it over to Dr. Stankowski.
Well, thank you, Justice Stratton. And hopefully people can see my title slide. Yeah, thank you for that lovely introduction. And thank you, OSU, for allowing me to speak today on forensic psychiatry. I am very passionate about it and always looking for an opportunity to introduce the topic to residents, students, etc. Can people see the title slide?
Yes, we see it fine.
Okay, beautiful. Thank you. All right, so 3 learning objectives for today. And I'll just give a little caveat that this is a huge topic. Forensic psychiatry is a big area, and I'm going to give a whirlwind tour. If anybody has any questions at any time, my email address is at the end. I'm more than happy to email, talk, whatever. My goal today, though, is I'd like to help you guys understand the purpose and practice of forensic psychiatry. What is it? Talk a little bit about the concept of capacity in how decisions are made both in psychiatry and forensic psychiatry, and then discuss or review some common forensic psychiatry questions. So, what is forensic psychiatry? Forensic psychiatry is basically the intersection of mental health and the legal system. Specifically, the American Academy or the American Psychiatric Association defines it as a psychiatry subspecialty in which scientific and clinical expertise is applied in legal contexts. And that could involve civil contexts, criminal, correctional, legislative, or specialized clinical consultations. So that's kind of a big mouthful. I broke this down a little bit into, practically speaking, if you work in forensic psychiatry, there are probably two big areas. The first is treatment, and the second is the area of conducting evaluations or assessments. There are other areas. There's administration, policy development, academics, teaching, but really the two cornerstone or linchpin areas are treatment and doing evaluations. Treatment, I'll describe a little more in detail, tends to happen in certain locations, corrections, state hospitals, community group homes geared towards criminal justice connected patients. And evaluations can loosely be broken down for criminal courts or civil courts. If you decided to do a fellowship in forensic psychiatry, it's a PGY 5-year. So it would happen after your psychiatry residency. It's a 1-year fellowship, and it really was the most interesting educational year of my life. It includes legal education. It includes treatment specifically in forensic or criminal court correctional settings. It includes evaluations, and probably most interestingly, writing up your opinion of different legal medical matters in a way that makes sense to a dual audience, being the court and your medical colleagues. And then when necessary, providing testimony in court to communicate what your opinion is. And so really, I would say this year fellowship I did, not only was it fascinating just to understand the legal background that underlies a lot of what we do in medicine, but it was also a really great way for me to improve my writing, my rationale, my justification. And I think even if I never practiced forensic psychiatry, it made me a better clinician, because I went from putting in the chart schizophrenia and not really bothering to justify the diagnosis to saying schizophrenia, DSM-5 criteria as below. And so I would recommend it to anybody. Why are we even talking about forensic psychiatry? Justice Stratton mentioned that this is an increasing need, and this is actually something that residents and students need to know about, whether you specialize in forensic psychiatry or not. And the reason is, hopefully made clear by these little quizzes, what facility treats the most mental illness? And I won't ask people to respond, but think about it for a second. And the answer is, kind of sadly, jails. Specifically, the Los Angeles County Jail treats the most mental illness of any facility in our country. Number 2 is the Cook County Jail, which serves Chicago. So basically, over time, corrections has become the place where most mental health treatment occurs, at least in large numbers. So that's kind of sobering. Quiz number 2. How many patients in Ohio's state psychiatric hospitals? We have 6 state psychiatric hospitals in Ohio, not correctional at all, just hospitals. But how many patients in these hospitals have a connection with a criminal court? I can tell you when I started 20 years ago, the answer was B, but it has climbed up. And this is a graph I recently got from Columbus, from the Forensic Director's Office. They put together some research of all 6 hospitals. And this reflects how the percentage of criminal court connected people, i.e. forensic, and civil, meaning people from ERs or probated, no criminal court connection, has changed over time. I mentioned when I started 20 years ago, it was about 50-50. You can see that fiscal year 2002, fiscal year is how the state talks about academic years. 20 years ago, in fiscal year 2002, 54% forensic, 46% civil. Last year, fiscal year 2022, 83% forensic, 17% civil. This is averaged over all 6 hospitals in the state, but I can tell you that my hospital, which serves Cleveland, Cuyahoga County, Summit County, we struggle to keep it at 83%. It's more like 90%, 95%. And what's the reason for that exactly? Well, it's because I think over time, community mental health is not what we need it to be. So what happens to people with mental illness? They end up getting arrested, or their mental illness gets uncovered in the correctional system. And I was talking to the head of mental health and corrections. There are about 50,000 inmates in Ohio jails and prisons, and 20% of them are on their mental health caseload. 10,000 people in our jails and prisons have some kind of mental health need. And that compares to our state hospitals. We only have about 1,000 beds in the state hospitals. So when we think of where do people with severe mental illnesses get treatment these days, it tends to be more in the correctional system than in the mental health system. And again, the reasons for this are myriad, but part of this is deinstitutionalization. As people in state hospitals got released to the community supports weren't there. COVID made all of that worse. And now mental illness is being uncovered in jails and prisons more than anywhere else. So I, as a result, do a lot of education of not only my fellow psychiatry colleagues about criminal justice and what we need to know about forensics to treat patients, but I talk to a lot of attorneys about mental illness. And this is an old commercial. I don't know if my little link will work or not, but let's go for it.
Put on my software. Two great things that taste great together.
All right. Well, that commercial just cracks me up because, let's see, I wonder how I can get back to my presentation now. So what's the point of that besides the fact that I love Reese's peanut butter cups? And I'm not getting any kickback from them for mentioning that. The point of that is, we can't really separate out the forensic from the mental health. The two systems, although they're two separate systems, corrections is very separate than our hospital system, different agencies, different regulations, etc. But the fact of the matter is, whether we like it or not, it is integrated. The chocolate and the peanut butter are mixed together. So we need to know what each other does. So a little bit about forensic psychiatry treatment. Treatment tends to occur from a forensic psychiatry standpoint in correctional settings. You just saw 10,000 mentally ill people on a docket in our jails and prisons. So the treatment needs in jails and prisons are huge. And this really ranges from people with an adjustment disorder. I mean, if you think about it, people in jail, they haven't been convicted of anything. They're waiting for trial for the large part, yet they're thrown together with a bunch of other people without privacy, waiting to see an attorney, hearing about a pandemic outside. I mean, I would have an adjustment disorder pretty easily if somebody locked me up in that setting. So people in corrections not only have what we would say minor mental health needs, but they also have severe schizophrenia, bipolar, etc., that is going to get worse with the stress of correctional settings and just their charges. State hospitals, as I mentioned, Ohio is probably a little bit unique in that we still are not 100% forensic. I've got colleagues working in states, California, Oregon, the West Coast and the East Coast especially. Hospitals tend to be 100% forensic, which is a whole crisis of what happens to indigent civil patients who need help and go to the ER and now need a bed somewhere, and the state hospitals, which used to be the safety net, are now full. So it's really kind of a crisis of care in our system. If you wanted to do the treatment in this setting, besides corrections and state hospitals, community, when people get discharged or when people's legal status change, you guys might sometimes see somebody who is voluntary this hospital stay, but the last time they were in, they were probated. Well, the same thing with a criminal court legal status. They might be voluntary today, but the last time we had them, they were here for competency restoration. Or maybe today they're probated, but next year they might be here because they were found not guilty by reason of insanity. So there's really a mixed bag of legal statuses in the mental health community. And when they're discharged in the community, it really helps to have an understanding of those legal statuses. The bottom line, though, of treatment is that clinical treatment is the same regardless of your legal status. There are no different treatment protocols for a voluntary legal status versus a probate. Same thing with a criminal court legal status. The medication's the same. And very importantly, the regulatory requirements are the same. I mention this because when the criminal court is involved in some patient care, sometimes staff get confused and think, well, wait, are we under corrections now? The answer is no. Just because a patient has a criminal court involvement and is in a hospital, that hospital is still a hospital, which means it's still Joint Commission and accredited, Centers for Medicare and Medicaid monitor, and it's regulated by those mental health agencies. Corrections is regulated by entirely different policies, agencies, etc. So it's an interesting tension, though, I can tell you, when you have this mixing, the fact that corrections and mental health is siloed and are two different agencies mean that collaboration between the two is really critical. All right, that was forensic psychiatry treatment. What if you want to do forensic psychiatry evaluations? And probably a lot of people who do that year-long forensic psychiatry fellowship do so because they want to do some interesting evaluations. The evaluations we all hear about on TV, court TV, or read about in the news, people want to be the one to interview Ariel Castro to see if he really had an understanding of what he was doing. Or sadly, with so many different shooting incidents, did those people have capacity to understand what they were doing? Did they know they were doing something wrong? So if you go into forensic psychiatry to do evaluations, those I mentioned before can loosely be broken down between evaluations that come out of a civil court and those that come out of a criminal court. Civil court is what you all as psychiatrists are already familiar with. Civil court is what you go to when you want to probate someone, when you are asking for permission to medicate over objection, when you're looking for guardianship. The purpose of civil court is really to protect people and property if the court finds that evidence is sufficient. And for civil court, evidence needs to be preponderance, which is 51%, or clear and convincing, which you could maybe estimate at maybe a 75%. And examples of this, besides the probate and guardianship, are disability determinations, fitness for duty, testamentary capacity or ability to make a will, malpractice. So that's kind of a loose way to group those evaluations. The other side of things are evaluations for criminal courts. And the interesting thing about criminal court is, as medical professionals, we aren't used to working with criminal courts in the course of our training. We are very used to working with the civil courts, again, with probate, medication, guardianship. But criminal courts, the whole purpose of criminal court is to punish lawbreakers if it's proven beyond a reasonable doubt that somebody did in fact break the law. And of course, our goal is also in criminal court, our justice system wants to rehabilitate, not just punish. But traditionally, medicine has not been involved with criminal courts and punishment. Well, but now there are questions that arise in criminal court proceedings that involve mental health. Specifically, is somebody competent to stand trial? Is somebody competent to understand what they did was wrong, or were they insane at the time? So because of these mental health questions that arise in criminal court proceedings, there's a role for psychiatry, and that's where forensic psychiatrists step in. Probably a lot of questions that arise in both civil court, criminal court, and maybe medical practice can be boiled down to the idea of capacity and the ability of the patient or person to understand facts and use those facts to make a rational decision. Capacity to take medication, capacity to agree to surgery, capacity to understand what you're charged with and maybe what you want to plead. So capacity really covers a lot of determinations, and a component of capacity when people are making decisions are that decisions have to be knowing. People have to have that understanding of facts. They have to be rational. You have to be able to use those facts to make a rational decision, and voluntary, free from coercion. So I am a chocolate fan, so I really enjoy this slide. And actually, once somebody sent me this chocolate, and I'm sad to say that it looks better than it tastes, but it's fun. I remember enjoying especially the dark chocolate and working my way through the ear and the hand and different organs. But anyway, I bring this up not to talk about chocolate, but to talk about even what seems like a silly decision of should I eat a piece of chocolate involves these components we just reviewed. So in my hospital, there's a hallway and people always bring in donuts or chocolate or homemade chocolate chip cookies. And I walk down the hall and I pass by the box of chocolate and I need to decide, am I going to eat a piece today or not? So to do this, though, I need to understand the facts, the risks, the benefits, the alternatives. I need to understand, all right, here's some chocolate. What are the benefits of taking a piece of chocolate? It tastes good. It'll be a little sugar rush. I love chocolate. The risks are, I mean, it's not that risky unless maybe I'm diabetic and I shouldn't. What are the alternatives? Well, turn away and go get an apple. And is this voluntary? It is. My boss is not saying you better eat this chocolate or you're fired. It's my choice. And can I rationally decide and communicate it? If somebody is actually holding the box and I need to ask for a piece, can I rationally communicate with them and say, may I please have that chocolate ear? So even the smallest decision involves this capacity process. Now, this is a big caveat. People can have capacity to make a decision even if it's not a good decision. People that we know and love and maybe look at in the mirror every day make bad decisions all the time. If I ate that whole box of chocolate and I did that day after day and gradually gained 100 pounds and developed diabetes, that wouldn't be a good decision. But you know what? If I'm saying, hey, I've got capacity to do that, I'm competent to do that, that's my choice. I don't know if you guys have seen on TV some of these food contests. People eat ridiculous amounts of food in 20 minutes or super hot wings. I mean, they look like they're invisible pain. And so one would question if that's the best decision to cause yourself distress to get a t-shirt for eating a 40-pound hamburger. But people do it all the time. It's not against the law. And moreover, we don't hospitalize people because we don't agree with their decisions. So this is a picture of Lady Gaga wearing a dress made of meat. She's got a little hat that's made of a steak. She's got a dress that it's a little gross if you look closely at it because there's a lot of pieces of meat and sinew and tendons. It's kind of a vegetarian or vegan person's worst nightmare, I think. Now, was this a good decision of Lady Gaga to wear this meat dress at a public event? Well, Lady Gaga wore this, she got publicity, and she's worth billions of dollars. And this was before she did her movie and her Oscar and all that. So in her case, this was a pretty good decision. And moreover, it was a rational decision. She knew that she'd get publicity. She knew that that would get her name out there and probably get her more business. And it made sense. Now, I could wear this meat dress to work tomorrow, and I could understand that probably people would look at me with raised eyebrows, maybe even question my fitness to continue to come to work. But maybe I decide I want some publicity at work and I want to shake things up and I'm going to do it anyway. That could still be a rational decision. It wouldn't be a good decision, but it would be a rational decision. So, what's the difference between somebody's capacity to make a decision versus competency? Well, capacity is the assessment of a physician, whether or not somebody has the ability to do those components, to understand the facts and rationally make a decision. But competency is actually a legal determination by the judge. And it's important to note that all adults, all of us are presumed to have capacity to be competent to make all decisions that we have the right to make as adults in America, unless and until a court has ruled otherwise. So for example, I've got patients at my hospital who have been opined to lack capacity to take medication or give informed consent. They've been found to be incompetent by a court, but they are still able to vote. They're still married. They still have children. Some of them have guardians of person. And in that situation, a physician has opined that they globally lack capacity, and a court has agreed and appointed a guardian. In that case, that person does not have a task-specific capacity or competency for anything. But otherwise, if they don't have a guardian, these assessments are very task-specific. So medical capacity probably can be boiled down to informed consent. And we do this all the time. And people have asked me when I've shown this slide in the past, what is my responsibility giving informed consent? How much information am I supposed to give to a patient where they can really understand the risks, benefits, alternatives? And the answer is, the standard is, what would a reasonable person expect? So if you're prescribing Tylenol, nobody expects you to go through every single black box or tiny little warning on the insert. They would expect you to go through the black box warning, but not all the tiny little nitty-gritty things. But maybe what they would expect is to hear, hey, Tylenol will help pain. It's not going to help your inflammation. And you really shouldn't drink alcohol while you're taking Tylenol because it affects your liver. You know, that's kind of a reasonable amount of information for that patient to make an informed decision. There are some exceptions to informed consent. If there's an emergency, you can give a stat IM without that person's permission or informed consent. If the court has ordered something, you can go forth. The person has a guardian. And interestingly, there is something called therapeutic privilege, where technically, if we as clinicians think that it would be detrimental to that patient's health to hear about the facts and make a decision, we can withhold that. I have never run across a colleague who has used therapeutic privilege in this country. But interestingly, there was a movie out a couple of years ago that had a family originating in China, I believe it was, and the American granddaughter learned that her grandmother was dying of cancer. And in China, the culture is different. The family and the practitioners decided to not tell the grandmother that she was dying. Instead, all the family wanted to get together and see her, but not tell her why. So they fabricated a wedding, a fake wedding, just to draw everybody together. But it was very interesting. As an American physician, I watched this and thought, wow, I just felt so uncomfortable that the doctor wasn't being straight up with this patient. But anyway, it's a good movie. So what happens if a patient doesn't have capacity? And specifically in our world in psychiatry, we are very used to, I think, having to look at involuntary hospitalization, civil commitment. And Ohio Revised Code has a statute that we're all familiar with on our quote unquote pink slip that explains when we can ask the court for involuntary hospitalization. We also have capacity to seek involuntary medication. And in Ohio, there was a legal precedent about 20 years ago in the southern part of the state. The case was called Steele versus Hamilton County. And the issue came up that Jeffrey Steele was a patient who was psychotic but not dangerous. He was refusing medication, and the hospital was kind of stuck. Hey, this guy's not dangerous, so we can't ask the court to involuntarily medicate him due to dangerousness, but he's not getting better and he lacks capacity. So in Ohio, because of this legal precedent, we now can petition the court for ability to medicate over objection if a patient lacks capacity to make a decision about medication and treatment. A brief mention of landmark legal cases and precedents. If you do decide that you wanted to pursue a fellowship in forensic psychiatry, one thing that's interesting is learning the legal history of why we do what we do. So for instance, I just told you about a legal case in Ohio that led to and directly influences current practice. For those of you who work in hospital settings and have experienced surveys by the Joint Commission, Wyatt v. Stickney was a legal case several decades ago where there was a state hospital in Alabama not doing the best job of proactive patient care. People were involuntarily hospitalized but not getting treated. And interestingly, staff salaries got cut because they were state supported. The Alabama cigarette tax got cut. State employees' salaries got cut. And the state employees kind of said to the patients, we think you should bring up a class action lawsuit that this hospital isn't operating correctly. Anyway, there was a class action lawsuit, and the courts got involved and said, you know, this is not fair. There needs to be a quid pro quo. If you are taking away somebody's liberty and putting them in a hospital, you need to treat them. Don't just keep them there and warehouse them. And they developed a patient bill of rights that we very much use with Joint Commission surveys, et cetera, today, including patients have the right to the least restrictive treatment setting. Patients have the right to be free from unnecessary medication and restraint. Patients have the right to a humane environment with qualified staff. So for those of you who have gone through credentialing and had to show your documentation, when you want to put somebody who's dangerous in restraints, but you need to fill out a lot of paperwork, this is why. It's because of this legal case that created some precedent and that protects patients today. And sadly, if we had done a job as psychiatrists and mental health professionals 50 years ago and proactively done this, there wouldn't have been a need for the courts to step in. But anyway, so some forensic capacities. Some of them arise from the civil arena, and that includes fitness for duty and testamentary capacity. So a brief example of some of these: fitness for duty is basically the capacity to perform your job. I once saw a guy who was a paramedic who never showed up on time for his shift. And that was one of the requirements of the job. It put people at risk because if they got a 911 call and he wasn't there, the EMS squad could not go out. When his supervisor confronted him and said, "Hey, look, you are not performing the requirements of the job. What's going on here?" He became very angry, to the extent that the supervisor said, "You know, I don't know if maybe he can't understand his job anymore due to some kind of mental illness. Maybe he doesn't have capacity anymore." So I evaluated him, and that consisted of interviewing him, interviewing his coworkers, his supervisor, getting collateral information, disciplinary records, etc. And what I needed to do was come up with a clinical opinion. Did this guy have a mental illness? If so, was it impacting his ability to understand the roles and needs of his job? In his particular case, it turns out he was having bipolar disorder that was not previously diagnosed. He was manic. He was having a hard time coping, and it was directly impacting his ability to do his job. So he did not have capacity for a while. He needed treatment, and he was able to return. Testamentary capacity is the ability to make a will. Now, to make a will, what facts do you need to know? You need to know your estate. You need to know your natural heirs. You need to know how probate works. And you need to be able to communicate that in a coherent way with an attorney making a will. So this was a case where this gentleman had a will for years and years in place that gave everything to his kids, and it was a lot of money. And then 2 months before he died, he redid the will, cut out the family. So the evaluation in a case like this, you can't interview the gentleman, you know, it has to be a retrospective evaluation of his family members, people who knew him, his physician, and looking at any medical or mental records to see, did he do this? Possibility A could have been, you know, maybe he found out that his kids had been secretly milking his bank account for years. He got upset and he rationally decided to cut them out of his will and leave all of his money to his favorite charity. In that case, he had capacity, there wasn't a mental illness. Or I needed to try to uncover, was there some kind of dementia or delusion that maybe affected his ability to make this decision? Turns out he did have a delusion. He became paranoid. He had some dementia. He thought that his family members had been replaced with imposters. And therefore, he was cutting them out of his will because he didn't believe they were really his family. So in that case, he did have a mental illness that impacted his capacity. What about some more legal cases? Competency to stand trial is the most common forensic evaluation done probably worldwide. And the legal precedent for this was from 1960. There was a gentleman who had a history of schizophrenia who was charged with attempted rape, and there was no clear test of his competency. So some people said, one doctor said, you know, he's oriented, he's probably competent to stand trial. Another evaluator said, he's got a history of schizophrenia, he's not. It went all the way to the Supreme Court, which came up with a standard that we use today. The test of competency to stand trial is, does the person have a current ability to understand what's going on and consult with an attorney? So it's kind of the same capacity we've been discussing. Can the person understand what's going on with court proceedings, and can they assist and communicate with an attorney? Put another way, if you're looking at somebody's competency to stand trial, the question would be, do they have a mental illness that impacts their ability to understand the facts of their court case and assist an attorney in making a rational decision about what to do? I saw a guy who was charged with assaulting his father, long history of mental illness, and on interview, very flat. He was organized, but he had a clear delusion that he was the Archangel Michael, I think, whose job it was to kill demons. And he didn't have any clue he was charged with assault. And when I looked at his collateral, this guy had no prior legal history. And jail, he was kind of quiet, a lot of negative symptoms, on meds for schizophrenia and compliant with them. So evaluating him included talking to him about, does he understand what he's charged with and what's going on in a court proceeding? He did not. Can he assist in his defense? In his case, he was able to communicate coherently and relevantly, but he really couldn't discuss legal strategies because he didn't understand he had broken a law. And I'm making the word assist circle because when people are not competent or lack capacity, in most cases, not just standing trial, but most decisions, people tend to understand the facts, but what's difficult for people is rationally thinking abstractly and manipulating those facts to make a decision. So in most cases, when people aren't competent to stand trial, it's because of this inability to assist an attorney. So what happened with Joe? Well, the pathway of this is, if in a court, the attorney or judge suspects lack of competency, the court orders an evaluation. The evaluator sees the person and either says, and I'm shortcutting because the evaluator is the one who says whether or not they can understand and assist. The court's the one who determines competency. If the outcome is the court finds them competent based on the evaluator's opinion, they just stay in jail, return to jail, live their life. If they're not competent, this is where the state hospitals step in. So Ohio has 6 regional psychiatric hospitals, and the mission is intensive treatment for people from ERs who need it and are indigent, typically, we're the safety net, and comprehensive care to patients committed by the criminal courts. And if somebody needs restoration, they're typically committed then to the hospital by the criminal court. A little caveat with these interviews, especially when you're doing them for criminal courts, malingering is always a consideration. Malingering is what? It's feigning, intentionally producing or exaggerating symptoms for a secondary gain. And the reason malingering is always a consideration in criminal court evaluations is there's always the consideration of avoiding punishment. It is a diagnosis, it's not really a diagnosis, so I put that in quotes, but it's a finding of exclusion. You have to make sure that nothing else is going on. But malingering is a consideration. And, it wasn't a consideration in Joe because Joe had a lot of negative symptoms and a history. But I saw a different guy, Sam, no history of mental illness, no negative symptoms, weird supposed positive symptom of seeing a burning squirrel running around the office, long legal history, called the jail. Hey, is he seeing burning squirrels in the jail? Nope. Inconsistent presentation. I was leaning towards thinking he was malingering. All right, the other big evaluation that forensic psychiatrists do, sanity. Sanity, or not guilty by reason of insanity, It's an affirmative defense, meaning the person saying, you know what, I did it. I did the act, but I'm going to prove that I didn't know I was doing something wrong due to mental illness. It's rarely used. This is highly publicized when it's used, but it's pretty rare, actually. There are only maybe 400 people in Ohio who are committed or have been acquitted under this legal status. And the upshot is that the defendant proves that although they committed the act, the actus reus, they didn't have the second component of a crime, which is the guilty intent or the mens rea. Why do we do this? We don't want to protect people in our American justice system. Sorry, we don't want to punish people in our American justice system if they were severely mentally ill and didn't know they were doing something wrong. Nobody wants to punish people who don't know what they're doing. And the British legal system, from which a lot of our legal system is derived, has been looking for ways to test for this for years, centuries. Initially, the courts said, you know, if somebody is so mentally ill that they are a raving wild beast, that's the test that they weren't able to know right from wrong, and they're not criminally responsible. That got refined over time. Not every mental illness presents as raving. And people said, you know, maybe it's if you have a delusion. And then it got a little more refined. Maybe it's not a delusion. Maybe it's if you can't control your behavior. Well, this is the poster guy for the ultimate test of criminal responsibility and really what we use today. So Daniel McNaughton was a woodcutter in Scotland who thought he was being persecuted by the British government, specifically Sir Robert Peel, who was a very popular guy in charge of all the police force. Actually, his name Robert Bob is why British police are called bobbies. Anyway, McNaughton shot Peel, missed, hit the secretary, and both the defense and the prosecution had physicians who all said he's completely delusional. They all agreed. The prosecution actually dropped the case and they said, look, we have nothing. He's clearly insane. He was clearly insane, but the Queen at the time was a little annoyed because this isn't the first time somebody shot at her or her government and claimed insanity. And she said, you know, you've got to come up with a good rule for when people are insane and not criminally responsible. And the rule is that you're not guilty by reason of insanity if at the time the person had such a defective reason from mental illness that they didn't know the nature and quality of the act or didn't know they were doing something wrong. And if you look at Ohio Revised Code today, this is pretty close to what we use. Ohio Revised Code says that a person can be found not guilty by reason of insanity if they prove that at the time of the act, they did not know as a result of severe mental disease or defect, wrongfulness. So if you go back to Joe, my archangel guy who stabbed his father, I looked at the collateral because he and his attorney were interested in pleading not guilty by reason of insanity. Well, I couldn't interview him at the time to find out what he was thinking then, but what I could do is look at the police report to see what he told police. What he told police right after this happened was that God had commanded him to stab his father because he's the Archangel Michael. And it seemed kind of clear Joe didn't realize that that was wrong because he didn't try to run. He was hanging out on the couch when police showed up. He didn't try to hide the weapon. He was holding the knife. And when I spoke to him, he still was saying, hey, I did nothing wrong. I'm the Archangel Michael. So Joe was pretty eligible for a plea of not guilty by reason of insanity. And basically, the path of this is once this is pled and found, there has to be a determination of what happens to Joe. Does he go to the community or does he go to a hospital? 9 times out of 10, the state hospitals receive people who were found not guilty by reason of insanity for treatment. So this is kind of the mission of the state hospitals a lot these days. We do a lot of treatment for people ordered for competency restoration from the jail. And we have a lot of treatment and discharge planning for people who are competent but plead successfully not guilty by reason of insanity and now need to be released. So, do you need to be forensically trained to work at the state hospital? Absolutely not. You need to be a competent physician. Does it help to understand some forensic criminal court stuff? Yes, it does, because it's the environment these days. I asked staff a little bit, what do you like about working here versus not? And this is both forensic and non-forensically trained staff. You know, the pros are that for better or for worse, when people are committed to the hospital for court-related things, it tends to be a longer commitment than if we get somebody from the ER. When I get somebody here from the ER, the average length of stay is under 2 weeks, which is still kind of long compared to private hospitals. When somebody is committed to us from the court, it can be weeks or months. The good thing of that is you get time to treat. There isn't, you know, insurance companies aren't calling all the time. When are you releasing somebody? Hey, today the insurance expires. So there is a time and luxury to treat severe mental illness. You have a team approach. We have social work, nursing, physicians. We have psychologists, activity therapists, engagement therapists. The cases are interesting. I can tell you all that after 20 plus years of doing this, there are surprises all the time, and very interesting ethical questions as well, because a lot of times the question is, what's good for the patient that also is safe for the community? It's very satisfying to work in a hospital where people are so sick and disadvantaged that they've ended up here. You know, I think when people have money and family and jobs and treatment responsive illness, they don't even make it to the state hospital or jail. So we tend to help the most disadvantaged people at the hospital. The cons are that it's not just the physician's control or the team's control. You've got to have communication constantly with the court. And you've got to be a little careful about wearing dual hats. When we do treatment, you're a clinician. If you're going to do an evaluation, then you're evaluating maybe somebody you're not treating at the time, so there's not a conflict. So that was my whirlwind tour. I'm very happy to take any questions. And again, here's my email address. Would love to hear from anybody at any time with questions about forensics, the state, employment, etc. So thank you all. And I'm going to stop sharing to see if I can see if there are any questions. I don't see any questions in the chat.
So it looks like we don't have any questions at this point, but feel free to email her at Dr. Stankowski. I think you'll put your email in the chat. Is that correct?
Yes, I will do that right now.
You can copy that and use that, or contact Dr. Niedermeyer or Joanna, who can get you that contact information. So we're glad that you were able to participate. We will be sending this on to others, other schools and other training hospitals and law schools. And we hope that you've learned something, but more importantly, we hope that you are inspired to perhaps go into this field. It is an area with huge needs, some of the most sick of our sickest, with the least resources to help them. And so any of you that are young and full of ideals and wanting to save the world, please save the world. There's people you can save one at a time, one at a time. I started working on this 35 years ago, and we had only 7 drug courts at that time. We now have over 280 specialized dockets, mental health, drug, veterans courts. We had officers trained in knowing how to deal with mental illness called CIT, which we did a grand rounds on. And we only had 100 officers trained. In Ohio now we have 15,000. So we are preaching the message of support and help, and we hope that all you will perhaps find this something that you want to do. And I see a chat. They're just thank yous. All right, with that, I think it's our time to end. Hopefully copy that email down quickly before we close it out. Thank you all for participating, and a very special thanks to Dr. Stankowski for going into this field, but then sharing your knowledge and teaching and educating and being co-chair of our Psychiatry and Treatment Committee that put this on as well. And thank you to OSU, Dr. Nettemeyer and Joanna Sinar. We really appreciate you doing the hard work and putting all of this together for us. And we look forward to sharing it with others. Thank you, and all have a good afternoon.